You're welcome back. This is The Law. It is your legal light. It is your health law. And we're discussing the Attorney General's role in prosecutions. And I'm excited to introduce to you our guest this afternoon, Dapaah Samuel Addo of Addo Legal Attorneys, has over a decade practicing as a lawyer and spent quite a considerable time in the Attorney General's department, and so will bring us very good education. Nee, thank you so very much for making time to join us.
Thank you.
Right. Obviously, he's not new to this platform. Also joining us via Zoom is Julius Opoku-Ejay, who is with Opoku-Ejay and Co. Julius, thank you so very much. Right. Here in the studio again is Albert Gyamfi of Total Legal Services. You remember him so well. The teacher who has been very helpful in making the law so easy to appreciate when he took on a number of matters on this platform. And Nee is also a law teacher. So two teachers, two people in the classroom and also in practice, helping us with this discussion this afternoon. Albert, thank you for making time to join us.
You're welcome.
Great. So now we begin straight away with the subject of our discussion. And as you know, in due course, we will open the phone lines for you to join us. I'm starting with you, Albert. What is the legal or constitutional basis of the Attorney General's function as a prosecutor?
Okay, so under the Constitution, there are some few positions which are mentioned. One of them is the Attorney General. So the Attorney General is created under Article 88 of the Constitution. And under Article 88, the only requirement mentioned is that the Attorney General must be a Minister of State. So you have to be a minister first before you qualify for appointment as the Attorney General. And as such, most governments or successive governments have created the Ministry of Justice. So whoever occupies the position of Minister of Justice also doubles as the Attorney General, even though there is no straight constitutional requirement that that should be the case. Now, under the same Article 88, when it comes to prosecution, the Attorney General is supposed to be the initiator and the conductor of all criminal prosecutions in Ghana. So the person with the duty to prosecute cases, all criminal cases in Ghana, is Attorney General. And as most people would know, criminal cases is the Republic versus the accused person.
Right.
The complainant is only a witness for the prosecution. That is why in Twi, criminal cases are referred to as abayamanie. You have a case against the state. So the Attorney General, that stands instead of the state to prosecute all criminal cases for the state. So that is the role of the Attorney General. He starts the case, he prosecutes, and he finishes for and on behalf of the state.
Thank you very much. Now, let's go to the man who has been in that place for quite a while. What does the Attorney General actually do beyond the broad, constitutional Article 88 provisions that, Albert has sought to explain to us?
Okay, so the Article 88, 3 and 4, broad talk about the functions of the Attorney General when it comes to the issue of criminal prosecution. Now, 88.3 deals with the fact that the Attorney General is the initiator. So the point is, the power to prosecute is in the is in the office of the Attorney General. And 88.4 then also allows him to delegate that power to any office or anyone that he deems fit and necessary. Because there are certain offices that, for example, tax-related offenses, officers of the GRA can be empowered by the Attorney General to prosecute. IOCO, for example, deals with economic and organized crime. They have prosecutors there who will be dealing with. Because other than that, the work of the Attorney General will be practically impossible.
So what you're saying is the Attorney General gives its powers,
of course, by what we call a fiat.
mandates them.
Yes.
Okay.
So they normally the practical process is that you train the officials who are being designated to deal with those offenses. ECG, for example, offenses dealing with electricity and illegal use of electricity, the SNIT, for example. So you have SNIT. So all those officers, there are certain specialized officers who are allowed to prosecute in the name of the Attorney General. But when you come to the office of the Attorney General, we have divisions.
Right.
So we have the Department of Prosecutions. And we have who we call the Director of Public Prosecutions. She's in charge of all prosecutions by what we call state attorneys. So these are lawyers employed by the state under the Legal Service Act, and their role is to assist the Attorney General to prosecute criminal offenses. So they are like the civil service arm of the Attorney General's department, and it is led technically by the Solicitor General. Okay. So if you look at the head of the
legal service
is the Solicitor General.
That's correct.
And so in the absence of the Attorney General, normally during the transitional periods, when there's one government moving on to the next, the Solicitor General actually acts as the Attorney General until a substantive Attorney General is appointed. That's the practical nature of our work. But when it comes to prosecutions, it is the Director of Public Prosecutions. So under the Attorney General's department, we have the Civil Division, which is headed by the Solicitor General, and we have the Director of Public Prosecutions heading the Prosecutions Division. In every region, the unique thing about Accra is that for Accra, the Director of Public Prosecutions deals with only criminal cases, and then the Civil Division of the Attorney General deals with the civil aspects, because all cases against the state also are against the Attorney General. Okay. But in the other regions, the Chief State Attorney is the head of the Attorney General's office in the region, and he deals with both civil and criminal. It is only in Accra where we have the Director of Public Prosecutions who deals with both the civil and the criminal issues.
Right.
Now, the Director of Public Prosecutions and the state attorneys do a variety of things when it comes to the world of criminal prosecution. So, for example, with MTTU advice, any case dealing with death, so it involves death, you would have to bring the docket to the Attorney General's office for advice.
Okay, so
generally.
you mean the police?
The police, yeah. So the police, and let me quickly mention, the police as well, up to a certain rank, normally an inspector, is allowed to prosecute what we call minor offenses, generally. And those happen in the district court and in the circuit court. These days, because we have some police officers being lawyers who are trained, in some instances, the lawyers who are police officers can come to the High Court to deal with matters to do with ex parte applications, for example, normally. But in the High Court, it is reserved mainly for the state attorneys to initiate prosecutions in the High Court. It's rare that I've seen a police officer who is even a lawyer initiating a criminal process in the High Court. It is rare.
Okay, right. And we just referred to the Legal Service Act 1993, and says that it creates a legal service department, so to speak, and that service is headed by the Solicitor General. The Act in Section 3 says the Solicitor General is the administrative head of the service. I'm just confirming what he has said. And he says the Solicitor General shall, in the absence of both the Attorney General and Deputy Attorneys General, perform the functions of the Attorney General. So you remember the explanation he gave. When there is change in power and at a certain period there's a certain lull, there actually is not a lull in the Attorney General's department. Subject to the directions given by the Attorney General, the Solicitor General is to supervise and coordinate the work of the divisions of the Attorney General's department and members of the service, and perform any functions assigned by the Attorney General. Yes, Julius Opokwe-J, what will you say preliminary about what needs to be said about the role of the Attorney General in prosecutions?
As my colleagues have already indicated, the Attorney General is responsible for every prosecution in this country. Everybody prosecutes at the behest of the Attorney General, whether it's the state attorneys, the police, Senate, as has been mentioned, and now the OS. Everybody is, who prosecutes has the right, is given the mandate by the Attorney General to do so. Preliminarily, this is what I will say. And also remind us that in this country, we don't have civilian prosecution. So nobody can prosecute a matter unless the Attorney General sanctions it.
Right. Albert, did the Attorney General do anything wrong in calling for a docket that the police was handling in the circuit court in respect of the Republic versus Patience Boche, Sarah J, Benjamin Sowa, Kweku Boche, and Malik Dauda? We call it the Cecilia Dapaah case. And then police submitted the docket. They reviewed the docket, gave advice, told the police what they needed to change, what they need to add, extra investigations that they need to do, among others, and they say to avoid duplicity in the charges.
All right, let me say that, just as my colleagues also stated, the role of prosecution, or the person in charge of prosecution in Ghana, is Attorney General. Under EI 5, the Attorney General, under the Act 30, which is the Criminal and Other Offences Procedure Act, can give powers or can delegate some of his functions to some people. And one of them is a police officer not below the rank of a sergeant. Now, a police officer not below the rank of a sergeant can prosecute cases in the circuit court and in the district court. So even though the EI says summarily, of course, every case is in the district court and the circuit court had to be tried summarily. So far as the person is not below the rank of a sergeant, they already have the authority of the Attorney General to engage in prosecution. But once already indicated that the person in charge of the prosecution is the Attorney General, he also exercises some form of supervisory role over these public prosecutors. And as such, the Attorney General has the power to recall a case docket. And some cases which are to be prosecuted by these public attorneys are to be submitted to the Attorney General for advice. Now, the Attorney General collects these dockets together with the statements, with the charges, together with all the evidence. He reviews it, and he has the right to prefer charges. Now, this is not the first time people are raising a lot of issues concerning the Attorney General coming in, or to put it, interfering with prosecution by the police. We all remember the case of Gregory Afoku, where at the later end of prosecution, just as when the judge was about to deliver his judgment, the AG entered a nolle prosequi and decided to start the trial all over again. There were issues raised about it, and Mafusa of blessed memory, the Supreme Court, stated that the discretion to prosecute or not is with the Attorney General. The discretion to prefer which charges and which charges not to prefer is with the Attorney General. So despite the investigations that the police will carry out, and despite the preliminary charges police will prefer against an accused person, the final say is with the Attorney General. And the Attorney General will usually do so in the form of an advice. And the police have to go in accordance with the advice given by the Attorney General. They cannot go contrary to it. So I don't see anything wrong in the police preferring an advice on the
AG preferring an advice.
Yes, preferring advice to the police on how to, just should I say, carry out that prosecution. And I've read the advice, and in my view, I don't see anything wrong with that.
We'll get to the substance of the advice shortly. As he spoke, he was referring to AG has gone to file nolle prosequi and so on. Just to use that for you to help us explain in the functions, in the exercise of the functions of the Attorney General in prosecutions, what are some of the powers that it exercises?
Okay, so the Attorney General also, as part of preparing a docket for trial, can direct the investigative agency. So IOCO can bring a docket to the Attorney General for Attorney General to prosecute. The police will bring, national security, bring dockets to the Attorney General. Any agency empowered to do investigations in this country ultimately will bring its dockets to the Attorney General for advice. Now, in giving that advice, the Attorney General exercises the right to send the docket back for further directions. Because at the end of the day, it is the Attorney General that will have to carry that docket to court to prosecute. And you don't want a docket that is full of potholes, or a docket that has so many questions around it that defense lawyers, good as Samson, will have the opportunity to enter the fray and make a mockery out of the Attorney General's office. So before the Attorney General will ultimately prefer charges, the Attorney General must be satisfied that the case that has been prepared by the police by way of investigation, that's where people must understand that it is the duty of the agencies of state that have been empowered to investigate, to build what we call a docket. It is for the Attorney General to supervise the process in such a way that ultimately when it comes before the Attorney General, he prefers the charges at least can lead to what we call a prima facie case. Okay. In other jurisdictions like the US, the district attorney or the attorney is actually involved in the investigations from the word go, from the start to the end. In our country, we've followed the British model, we've divided the two, so the investigation is carried out by the police. They bring the docket, the Attorney General will review the docket, he would give his advice. If he feels that there are necessary additions, further questions to be asked, further things to be done, because it is the burden of the prosecution in any criminal trial to ensure that it produces evidence beyond a reasonable doubt. That's the standard. It's a very heavy burden. So the power to prosecute, and I like the case he cited. In that case, the court also pointed out by Puamang that the power to prosecute is a discretionary power. The decision to either prosecute or not to prosecute is subject to the requirements of Article 296. It is not an open-fettered an absolute power. So
what is Article 296?
296 talks about the use of discretionary power. It must be candid, it must not be arbitrary, it must be in accordance with due process, it must not be capricious. So there are standards. And any public officer that exercises those discretionary powers is fettered under that. And so in doing so, or in exercising the power to either terminate a prosecution, that's one of the powers of the Attorney General in a lawful prosecution, that the Republic is not interested in proceeding with a prosecution based on certain considerations. There's a guide on on prosecutions that is supposed to guide a public prosecutor as to how to do its prosecution. And there are a number of considerations. Can be national security, can be public interest, can be a number of things. Maybe the person is an infant, maybe there's not a cooperative witness. So if you remember the case of KKD, the fundamental witness, the victim, decided that she wasn't going to cooperate. The power to subpoena was there, but it makes your work, very difficult. So there are a number of considerations why the Attorney General may decide to terminate a prosecution, or why the Attorney General may decide to continue with the prosecution. In directing the police to go back and do further investigations, what we all must ask ourselves is whether that advice or that the exercise of that discretion is being guided by the considerations under Article 296. And so, yes, people may have issues. People may have questions. You see, the reason why there are some questions in respect of this particular matter also arise because the case has traveled other realms. If I listen to my brother Martin Kpebu yesterday, he makes us understand that an aspect of the case has actually gone to court and has come back. The Attorney General is also a political person. And so there must always be public interest, especially from CSOs and from all of us, as to whether the office and the power that is embedded in the office is being used for the ultimate public good. And so if you hear people asking questions about the advice and the further directions to the police, the ultimate question that people want to understand is that in exercising or asking the police to go back and do the further follow-ups that they are doing, are they being directed to ultimately ensure that the complaint that has been brought before the police and the work that is being done by the Office of the Special Prosecutor is being done to complement that work? Or is the investigation being used to obfuscate or to divert attention or to make it difficult for the Office of the Special Prosecutor to also be able to do its work. So we need to examine all those things and be sure that ultimately it is the interest of the citizen that is being
So now
protected.
let's comment getting into the detail of the advice and whether or not it is the best, it is not the best from where they sit, if the Attorney General is doing something wrong or right. So, Senior Pukweje, what do you say from what you have read of the advice that the Attorney General has given? First of all, let's help educate the public. Do you see what the Attorney General is doing here as an interference and seeking to, as it were, interfere with what the Special Prosecutor is doing? It doesn't look like there's any attempt to do any such thing, is there?
No, not at all. Years ago, after school, I did my national service in the Attorney General's office, and I was in the prosecutions division.
Oh, great.
So I've had occasion to give advice, such as we see the Attorney General doing in this matter.
Okay.
The public seems to have taken a very keen interest in the political or the politician involved, and so are very uncomfortable when the other aspects of this whole matter is being looked at, and there's suspicion that the Attorney General may want to, as Nee said, obfuscate the whole matter. But the Attorney General is very right. Look, there are huge sums involved here. Whether Madam Cecilia Dapaah came by these monies properly or not, there's a case of stealing which must be investigated.
That's right.
She complained that she's lost money. That must be dealt with. The Attorney General, from my understanding, is not looking into the corruption-related matters. The OSP is dealing with that. And so far, from what I see from the advice, the Attorney General is on the right track, advising the police to do certain further investigations, to take certain statements, and to clarify certain things. There are charges which have been lumped together, which may fail in the prosecution because of the way the charges have been framed. They've been advised to separate them. This is exactly what the Attorney General's office is set up to do. I mean, I'm not saying the police are not competent, but if the Attorney General's office had sufficient lawyers to do all prosecutions, I'm sure this matter would not have gone to court in the manner in which it has been presented until now. So the Attorney General is certainly on the right track.
Right. So I'm coming back to Albert. And Albert, the Attorney General, among others, is asking the police to do further investigations and to bring in this. They say, quote, "We note that you are investigating the acquisition of various properties by the first and second accused persons." That is those who have been charged for stealing the money belonging to Cecilia Dapaah. And it says, which investigations border on money laundering. The advice rendered above implies that you should broaden the investigations on money laundering and other financial crimes to cover the complaints, in order to establish the matters raised above. This is in light of the huge volumes of cash reported by the complainants to have been stolen from their home. So if you follow the process so far, part of the stolen money has been used to buy property. Okay. Cash, $70,000 has been used to buy property by a young lady who is only a house help and is not reasonably expected to hold that amount of money. The people who sold the property to her and so on now may have to come in to answer questions about money laundering. Somebody reads this and says, but the special prosecutor is doing these things. Does the special prosecutor's law allow it to do money laundering?
All right, so if you look at the law establishing the Office of the Special Prosecutor,
right,
it is mainly established to investigate public corruption. So if an individual decides to engage in money laundering, which is also a crime, it is not a public corruption, and that will not call in the office of the OSP. However, the advice given for the complainant's source of wealth to be investigated, in my view, is in the right direction.
Okay.
You make a complaint that I have $800,000 at home, I have $200,000 at home. They were separated into two, but the police decided to lump them together.
That's right.
I have 300,000 euros at home, and these persons have stolen them. But we look at the properties they have acquired, their net worth. We gather all properties that they have acquired, movable properties subsequent to that, and it's not even equivalent to about $200,000. Obviously, no public prosecutor will take such a case to court because you cannot prove it. One thing about stealing is that if you are to secure a conviction for stealing, you are supposed to prove that there has been a dishonest appropriation. The person must have something, and that thing should have been stolen. So if the complainant never had a thing, you cannot successfully prosecute a person for stealing something that did not exist. So did they really have $800,000, $200,000, and 300,000 euros at home? Because if they did not have it, then those persons cannot be charged with stealing. That is the first one. So in the advice given, whether those monies were in the home is critical. Number two, the fact that you're a complainant does not mean that you cannot also be investigated. In my view, if you have such colossal sums of money at home, no matter the source, I will not go into where she acquired it, but no matter the source, it's a subject of question. Why is this money in your home? And if the police should also conduct the investigation and it turns out that that is also an avenue for money laundering, they can also charge the complainants in a different on a different docket for money laundering. So if the Attorney General has looked at it and he feels that no, there are various persons who can also be brought into the fray. You mentioned those who sold the property, $70,000 house to a young person without, excuse me to say, any meaningful source of employment, without you knowing where the money was obtained. You could be charged for abetment of money laundering. So I think if, like my senior said, if the Attorney General is to take this case up, you're going to have so many counts involving so many other people. So the call for further investigation is in the right direction. People should not forget.
So as you said, potentially the 10 counts may end up being more than 10 counts.
And the accused persons may end up
being more.
So I think people should also understand that the Attorney General is not an investigative body. Yes, they are supposed to assist, but your body is responsible for investigation. But after the investigations have been done, it's the Attorney General that will take the case docket to court. So if he feels that he will require further evidence in prosecuting this case, it is in the right direction. And I think the Attorney General should be commended for he instructing the investigative body to carry out other investigations to establish the guilt or otherwise of the accused person. And where he felt that some persons are not supposed to be charged, in this case, the father of the first accused person is not supposed to be charged because he feels 10,000 Ghana cedis from my daughter to me, after all these years of work, is money that cannot be classified as dishonestly receiving, so the charges should be dropped. I think it's in the right direction. Like my brother said, he wouldn't want a defense lawyer to ridicule him in court.
So in respect of the girl's father, this is what the Attorney General says. He says, there is not enough evidence to show that the fourth accused, father of the first accused, knew that the money his daughter gave him was stolen. Even though the first accused, that's the daughter, claims in one of her statements that she gave her father 50,000 Ghana cedis. She explained in another statement that she initially gave him 10,000 and asked one Asibi to give him an additional 4,000. She later got to know from her father that Asibi did give the money to him. The fourth accused, that is the househelp's father, explained that he knew his daughter was working in Accra, but had no idea who the complainants were. He received 10,000 from her daughter and spent it not knowing that the money was stolen. This explanation appears reasonable and makes the evidence on record insufficient to sustain a charge of dishonestly receiving against him. We'll be right back. You're welcome back. This is The Law. It's your legal light. It is your help law. And here on The Law, we make sure that we're giving you the best of legal education. As I indicated, and as we always do, we'll open the phone lines at the right time. But I need to caution ahead of it. On this show, it's a legal clinic, and we seek to give you pure legal education, platinum legal education. I know this issue has a lot to do with some politics, but when you come in, take off the politics. Here, we are simply turning a classroom to educate you. Now, so Nia, I come to you on what the Attorney General advised as far as the fourth person who has been charged is concerned. The fourth person is Patience Boche's father. Patience Boche is the house help. She had alleged that she had given 50,000 to her father. So the police put it in their charge sheets.
Correct.
And the brief facts explain it. But they say that when you read Patience Boche's own statement, she says she gave the father 10,000 and then asked one Asibi to give him 4,000. Later found out Asibi didn't actually give the money. She also blew it. Right. Thief man, thief man, the another thief man, thief that thief man. Now, Attorney General says on the basis of this, you can't put the father in this case and charge him with 50,000. That's good advice, isn't it?
Go back and do your work properly. So that's actually the role of the Attorney General, to ensure that. And if you look, a lot of people are missing something in the advice. In my time at the AG's department, the police have a limit on which they can prosecute.
That's right.
That's a very important this thing. And it is done because of some of these problems that are associated, because of the technical lack of knowledge in the law. And not to say the police prosecutors don't do a fantastic job. They actually, my ideal is that every single district will have an Attorney General's office. You understand? That should be the ideal, and something that I have been urging the current Attorney General to roll out, that perhaps over the next 10 or 15 years, we should have a situation where every district of Ghana should have an Attorney General's office. And that's one of the reasons why we should open up legal education. Because you see, if you have the Attorney General's office in every district, you will have a lawyer review every case. And it will also help to take down some of the human rights issues that you and I have to deal with in court all the time. But back to the specific subject matter that you talked about. So the Attorney General's office, in giving this advice, gives the advice with the eye for a proper prosecution. Other than that, fundamentally, the charges you have preferred should actually be thrown out immediately they are put before any judge, because they are not only defective, they are fundamentally defective. They are what we call elements of a crime. Every crime generally has an act to do with it and has the mental intent behind it. Our law is clear on the definition of what is an offense, that nothing is an offense unless it is written in law and a punishment prescribed for it. The elements of an offense, so if you look at our criminal code, every offense has what we call the offense creating section and the offense definition section. Each offense is defined. And so when you are preferring a charge against an individual, you must be careful that the act that you said the person, the prohibited act that is in the law, is also matched by what we call the prohibited intent, except it is an offense that can stand on its own based on the fact that of the act itself, without anything more. And so the Attorney General in this instance has the responsibility to direct the police to review their docket and to ensure that when they take this matter forward to court, it will be properly done. And then also they reminded the police that there's a directive from the Attorney General's office as to a specific amount. So there's a ceiling that has been given the police prosecutors as to what they can prosecute. Because the more colossal the amount, the fact that the Attorney General wants to ensure that proper investigations have been carried out. Not to say that those that are prosecuted by the police are not done with proper investigations, but when the amount is that colossal, and you imagine that these amounts, for example, are state funds. Imagine that the amounts involved are state funds. If the police misstep, the state will lose everything. So that is why there's a ceiling as to what they can prosecute. And I'm happy the Attorney General's advice reminded them that this docket should have been to the Attorney General in the first place.
That's right.
Because of the amounts involved. And there's a limit to what you can do. So I'm happy the Attorney General reiterated that. And now that it is the Attorney General's department, in coordination with the Office of the Special Prosecutor, and that is what I keep emphasizing, that all these agencies are created to complement each other. And maybe we'll get to the other side of the latter part of the issue about how they complement each other, whether one is stepping into the shoes of the other. But in terms of a purely technical overview of what has happened or audit of what has happened, everything that the Attorney General is directing is within the mandate of the Attorney General's office to so do.
Okay.
When we come to the other optics about it and the role of the two offices, maybe we can answer that also as well.
Right. So, Opokoje, it's instructive that in this small piece that I read out, the Attorney General says, so as a matter of fact, what was given to the man, the father of the house help, is 10,000 Ghana cedis. And that is reasonable. That it doesn't matter what work the daughter does, 10,000 is reasonable for her to be able to make and give it to the father. And the father didn't know that it was stolen money. So Nee mentions there must be the mens rea, there must be the mind that knows that this is wrong and goes to do the wrong, which is also a crime. So it's good advice, isn't it?
It's very good advice. Very good advice. As Nee mentioned, every offense has its ingredients. If you are charging the lady's father with receiving stolen property, he must reasonably know it is stolen
property. Yeah.
If she gives him 500,000 cedis, 500,000 Ghana cedis, then he must necessarily ask, where did you get it from? How did you come by it? If you don't ask that questions, then it can be assumed that you yourself know the source, so you don't want to inquire. Knowing what the person does, knowing the job. I mean, even if you don't know her actual occupation, you know she works for some people. You know the position that she holds. I mean, it's like money running through your bank accounts. For some people, the millions of Ghana cedis runs through their accounts on a weekly basis. It doesn't raise any eyebrows. But if you are somebody who receives 5,000 cedis a month in your account, and suddenly 100,000 cedis drops in it, the financial intelligence people will ask you questions. Where did this money come from? Because it is unusual. So for 10,000 cedis, I think the Attorney General was right that this shouldn't be about somebody if she's working hard enough to save that and give to her father.
Father said he also didn't know that this was stolen money.
Yes, he said clearly he doesn't know it was stolen money. I mean, so it's difficult to hold him. This is a charge which is likely to fail.
The first time I read this, what caught my attention immediately, and which I have paid attention to, and myself, I publicly, acknowledge that this was important advice to the police, was on page 8, where they say that it is important for the police to establish the ownership of the various amounts of money dishonestly appropriated to avoid any duplicity in the charges. Now, we say a charge sheet is bad for duplicity, and the law is clear that when a charge sheet is bad for duplicity and leads to miscarriage of justice, then that charge sheet cannot be the basis on which a conviction must be obtained. So when they say they want to avoid duplicity of charges, what do they mean?
Well, what are you charging them with? We see stealing in this case. Who has stolen what? If you are lumping two people together as stealing, and don't forget that there are different complainants in this matter. There is Madam Cecilia Dapaah, and then there is her husband, whose property has been stolen, and who stole the money. If you lump it together and you bring the two people, the two accused persons, as having stolen money, what have they stolen? Whose money have they stolen? How much did each one of them steal? You need clarity on that, otherwise the charge will fail.
Right. So, Albert, our courts have said that in this case where there was a cement matter, one of our favorite judges of blessed memory has said that the charge sheet ought to contain a count, but for economic purposes, we are able to put a number of charges on one charge sheet, but it must be distinct and clearly stated out. So the duplicity thing, that makes the charge bad for duplicity. What does it exactly mean? In this case, we are talking about where they say there was pilfering. Yes. So somebody stole X amount this day, another stole X amount that day. The same person who stole 20,000 today, a month later stole 50,000. Can you put all of that together and say stealing in respect of A1?
50,000.
Yeah.
I think that will be why the Attorney General would have to come in. And,
right.
And most people do not understand. These are the technicalities of the law. And one thing is, if it is indeed true that these people have stolen 1 million Ghana cedis plus all the other things that they have stolen, definitely they are going to have a good defense attorney to represent them. Right. One thing about law, if you're a defense attorney, which I am one, is that you first look at the technicalities.
We all are. Three of us, the fourth.
you first look at the technicalities of the law before you look at the merits. If we talk about the merits is who is guilty and who is not. But if you have a technicality, you can get your client out of the charges without even a single witness testifying in the case.
Because he presumed innocent.
Exactly. So that is why when the case comes before the police, and in this particular instance, I am surprised that the AG would say, we asked you to bring the matter to us for advice, and we'll remit the docket back to the police to continue with the prosecution. If they are to continue with the investigation, I don't have any problem. But if they are to continue with prosecution, that is where I have issues. Probably
So you were hoping that they would take the whole thing and do the prosecution?
Yes.
The last sentence.
No, the last sentence says they are to continue, we are remitting back to you.
So
That's
read it.
Your blah, 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 duplicate docket, it's returned to you to enable you comply with our directives.
So this is how it is. If the Attorney General's office was satisfied that everything was okay, what they will do is that they will retain the docket and ask you to do what? To take the charge caution statements, bring back the charge caution statement, then they will continue. If they return the docket back to you, it means that you are supposed to go back and do everything that they've said and then bring it back. So it isn't that they are sending it back for prosecution. No.
So there's a possibility that in the end, the Attorney General will say,
the Attorney General
we take over the case.
Because if you look at this thing, they have in my time, police were not supposed to do prosecutions up to, I think it was 100,000 cedis or so back then. So any matter above that amount limit is done by the state attorneys, even in the circuit court. That is why in the advice, the first thing they told was that looking at the amount of money involved, they had no business starting the prosecutions at all. They were supposed to bring the docket to the Attorney General's office for advice. So it kept reminding them that there's a circular from the Attorney General that any amount above a certain limit, and it is because of the fact that some of these prosecutions involve state funds. So if, for example, if the Attorney General is in Accra, there may be somebody who has stolen money in, let's say, Navrongo, involving maybe a rural bank. And the amount involved may be 3 million, 4 million, 5 million. If the police mishandle the prosecution, the state will lose that money.
Right.
So there's always a limit on how much the police prosecutors are supposed to do, even though in practice, they ignore it. So there's a line there. I just would pick that line on the page for you and give you. While you go on with your...
My student has given the clarification. Because if not for that, I'll be very surprised. And I think probably the Attorney General wouldn't want to get itself involved because of the political connect. Even just for advice, people are raising issues. How much more taking over the case?
All right, so we're opening the phone lines now. You can join us with very brief questions because we have about 5 minutes to take your questions as my guests continue to help you with understanding the role of the Attorney General in prosecutions using this particular case. So again, Opoku, whilst the Attorney General says, we want to avoid duplicity, we don't want to have a bad case, and then the people will win against us.
Look at page 5. This is just to, it says, before proceeding to offer advice on the charges, we noted that even though the monetary value of this case exceeds 500,000 cedis, you have already taken charge statements from the accused person in this case and arranged them before court on various offenses without recourse to this office. This is contrary to the earlier directives issued to you by the Attorney General dated 21st April 2023 to submit dockets on cases in which the monetary value exceeded 500,000 cedis to this office for advice.
Good.
For advice.
Yes.
All right.
So there's the rule that it's always been there because of the fact that because of the amounts involved and the fact that some of the amounts, in fact, a lot of times, the amounts actually belong to the state. And so if you're not careful with the kind of advice...
You have made that point.
Yes.
So the circular to the police has been that, as the Attorney General says, has been that you don't prosecute a matter where the amount involved exceeds 500,000. In this case, you are actually saying over $1 million, almost like 1.5 million US dollars in quantum. So they didn't have the power to continue with it. That also tells you that the Attorney General will take over this matter.
Oh, yes.
Because
it will take over this matter.
So when they take over, people should not raise any questions.
No. It will actually take over the matter in respect of the offenses that relate outside the mandate of the... That's why I am looking ultimately at some cooperation between the Attorney General's office and the Office of the Special Prosecutor to ensure that there's not an overlap.
Right. Now, Pukaji, I was coming to this point where there's some curiosity that came up. That even though this happened in October of 2022, the complainant and her husband, the two complainants, are said, Cecilia Dapaah is said to have made her complaint to the police on the 1st of July 2021, and then her brother, a certain Henry, also came to make a confirmation of the fact that the money was in a box and it was so on the 4th. The question is, by the time we're being told that they are making the complaints, the police had already done the investigations, retrieved monies, seized houses, seized vehicles. How is that possible that the complaint that they filed is later in time to the investigations that have been done? So I get you on that, but I have Ernest on the line. Hello, Ernest.
Good afternoon, Samson.
Good afternoon. Quickly with your question.
Yes. Samson, in fact, I don't have a question. I'm very, very happy about this education this afternoon. If all lawyers would speak the word of politics like you are doing, I think Ghana will go high. Thank you for the program.
Thank you, Ernest from Wasa Ekropong. Yes, Opokaji, what do you say? I said that looked bizarre. What do you say?
Well, you see it as bizarre. I see it as extremely curious. I'm wondering on what basis the police done their investigations, retrieved money, retrieved assets, when there was no complaint. Because if you make an oral complaint, you go to the police station, very often the complaints are initially oral. But then the complainant gives a written statement. And then if the police require the complainant to give some further statement after they commence their investigations, that may be done. So how did the police get to start their investigation in this matter? Went to Tamale, went to Buram, all manner of places. What was the basis? Was it just an oral complaint? I'm not sure what happened here, and I find it very curious.
And I come to Ni and to Albert again. When she gives a complaint on the 1st, and her brother comes to corroborate it on the 4th, there is the amended charge sheet on the 5th of July. So there was a charge sheet already going on. But by the 5th of July, it was amended. And then by the 20th of July, it was amended the second time. And the things the Attorney General has noted did not feature there, as in the separation of the money and everything. Yes, Justice, you are calling from Otsu. Quickly, what's your question?
Okay, so Samson, thank you for giving me the opportunity. The issue, therefore, is that I want to find out if I have a legitimate document backing my land, and somebody also pertains to have the same land without a document. Can I proceed to court and win?
Thank you very much. You may go to court and see what happens. But once you have a documentation, that is prima facie, we say in law. It suggests that you have shown evidence that you are the owner. Thank you, but that's all we are discussing. Yes.
Yes. So I feel it depends on the reason. So someone could go to the police station, make an oral complaint. I have money in my house, and I think it's missing. I don't know who stole it. So the police can go ahead, conduct investigation. Who are the people living in their house? Let's investigate. Let's find out. So now the police decide to investigate each and every person. They find the first accused person with certain things which are fishy. They find prima facie, something to suggest that she has stolen. This is what we found. What do you have to say? Then I want to make a complaint against this person for stealing. So the investigations can happen before the person decides to actually make a complaint. The US, they call it press charges.
And there can be a charge sheet in court even before the date for the complaint?
No, so you realize that the charge sheet was in court after the complaint, but the amended charge sheet was what occurred after the complaint.
Yes, a day
later,
after.
After the brother had confirmed. So there was a charge sheet in court, and the charge sheet was based on the complaint. But after the brother confirmed, after the first charge sheet, there was an
the charge sheet was not based on, the complaint was the 1st of July.
Yes.
But you see, what's this?
The brother makes the confirmation on the 4th of July. The first amendment of the charge sheet happens on the 5th of July.
So from 1st to 4th, there could be a charge sheet.
No, you see that
there was a charge sheet before then.
Before the 1st?
Yes.
When the complaint was
Exactly.
made.
Exactly.
But you see, the interesting thing is also this. If a complaint has been made, once the complaint has been made, the investigation process drives. And so that's it.
Interesting. Our very last caller, Chief Musa, you're calling from Wale Wale. You have just 30 seconds.
Yeah, good afternoon, Samson and the panelists. Something is bothering my mind. Your program is excellent. But what I want to know is that if somebody has a specific amount you have to keep with you, that's my question, in the house.
Thank you very much. You don't have a specific amount you have to keep with you, but that's not what we are discussing. What will be your final words as we close on the role of the Attorney General? And thanks for the explanations that you have given so far. I'm sure we have educated the public sufficiently. In some 15 seconds, what will you say, Opokweje?
The Attorney General is doing what is expected of his office. We just hope that the public should have confidence in what they are doing, unless there is reason to doubt from the actions of the Attorney General. Let's just allow them to do their work.
Thank you very much, Ni.
I think that we are looking forward to the collaboration. You see, that's the thing, the collaboration, so that the reason why the OSP's office was set up will actually be fulfilled. Because clearly there was a deficiency, and that is why the office was set up.
Thanll you. Yes, Albert.
Right, I'll use my last words to reiterate the call that the office of the Attorney General should be separated from the Minister of Justice. The Attorney General should not be a politician, so that at least that public perception of politics would be out of the way of the Attorney General, so he can do his work as
Thank you so very much. My guests have been Julius Opokweje and co Nikpako Samoa Ado of Ado Legal Attorneys. He's also a lecturer of the law. Albert Gyamfi is with Total Legal Services, and he's also a teacher of the law as well. I'm Samson Lardy Anyenini. This has been The Law. It's your legal light. It's your health law. Have a good afternoon.